Mic check 1, 2. Hello, hello. Welcome. This is Just Human episode 372. I am not sure exactly what topics I'm going to throw into this episode because one of them I know is going to take a long time. And it may be the only topic that it makes sense to fit into an episode of the podcast without the podcast being like 3 hours long, which I'm not against doing 3 hour long podcast or even 4 hour long podcast. Or I think I've done a couple that were 5. But I think this one, it just might be enough in and of itself. And what I'm talking about is the Fulton County 2020 election probe that's going on. I talked about in the last podcast episode where I updated you on there being another special counsel to the AG who's been appointed, not a special counsel with his own office and his own budget and his own investigators and like the whole special counsel thing like Mueller was and Durham was and all those guys. Not like that, but just a special attorney or counsel to the AG who has been given, it's a U.S. attorney, just like Thomas Alvis is the U.S. attorney for Eastern District of Missouri. I told you guys about how Dan Bishop of the Middle District, I think it is, of North Carolina, has also been given a special counsel status. And in this context, what it means is they're a special counsel to the Attorney General, and the Attorney General has given them authority and a task. In this case, with both of those guys, it appears to be investigating the 2020 election wherever the evidence leads them to go, wherever in the country it leads them to go. And they are both focused on Fulton County. Thomas Albus, of course, got search warrants for the Fulton County record storage facility, and they raided it back in late January of this year. And then last week, I think it is, Dan Bishop sent subpoenas to Fulton County and wanting to get all of their records on who worked the elections, whether they were employees of Fulton County or they were volunteers. But he wants all of the contact information and when they worked. I think I went over in the last episode exactly what it all was. Anyway, and we're going to go over it again because what I want to do in this episode is I want to go through the judge's order that closed out the case, that closed out the lawsuit that Fulton County made or filed to get those records back. Right after the raid, like a week later, Fulton County filed in federal court in Georgia seeking the return of the 600 plus boxes the FBI took. And that case has played out and it has frozen part of the investigation. It's prevented DOJ and their investigators from going through those Fulton County 2020 election records until now, because the judge said, nah, you don't get them back. DOJ search warrants were good. Their probable cause is good. And they'll return those things when they're done with them. But I want to go through his, pardon me, I'm trying to record. I want to go through his order, even though it's long, but I want to go through it because I think it gives a nice background on the case and everything going on in Fulton County. Can y'all see this dog? Y'all see this dog? This dog thinks this is the Hercules show. Is this the Hercules show? Is this the Hercules show? It's just me and him right now down here. Athena's upstairs with my wife, snuggled up in the bed and having some beauty rest. They're both having beauty rest this afternoon. Me and you are chilling, reading court docs, right? Right? That's what we're doing. You got anything to say? All right. I'm going to need you to let me keep talking, okay? Don't interrupt anymore. Okay, you've made your appearance. I don't know if y'all saw there's a little heart on his chin. Oh, gosh. I love you too. Yeah, I love you too. Okay. All right. Can you get off now? Oh. Don't unplug me. Oh, so much hair. Okay, go get your ball. Go get your ball. Get your ball. Okay, you didn't get it. Well, go get your bone. Whichever one you want, go get it. Okay. Anyway, so I want to go through that order because I think it'll give us a good background on what's going on in that case, and it'll just better inform us on what's going on with this election probe. One of my motivations for it is that we've been fed so much junk about the 2020 election and about what happened in Fulton County. I mean, really, when you think back to all the different theories and explanations and accusations and videos and all of the grifting that's gone on around 2020 election stuff, um, you know, MAGA has been fleeced of money and attention and credibility by a ton of high profile and low profile grifters who just repeat and chew on, regurgitate whatever slop they find as regards the 2020 election. And I'm kind of ticked off about it. I'm kind of ticked off that the bar got so low and that people accepted things that never made any sense and then repeated them on their socials, and that MAGA's allowed itself, a good portion of MAGA anyway, has allowed itself to be convinced of things that don't make sense and have never been proven about the 2020 election. So one of my motivations in going to this is that I think this will clarify some of those things because it actually is a court establishing some facts and setting out what this just a piece of what this probe is about. So we've heard it said about no court would look at the evidence and no court would take up the case. Remember all of that? Well, this court hasn't taken up the entirety of the case, but this court is dealing with a search warrant that concerns 650 plus boxes of 2020 election records for one single county. And it took up the case. And as part of that, it had to review the merits, I believe, of the search warrant. So here we have something actually significant, something actually substantial that we can go to and we can reference and we can learn from and we can get insight into. Something that's actually like has a firm factual basis, unlike most of what has been highly trafficked on True Social, Telegram, X, and Rumble, and all sorts of other sites, and by all sorts of accounts that really they've burned all their credibility up with me long ago. I hope they have for most of you anyway. You also. So, all right. I hope you guys are with me on this. I hope you are as aggravated and as tired of being led on and lied to and misled and disinformed about all of these things, because there's been a ton of it and it's hurt MAGA. So, all right, you guys know where my link tree is and you know what's on there, where to follow, where to watch, where to listen, and all the different ways to support. You can find my threads on there. justhuman.substack.com is the best way to support what I do. It's the best way to fund my caffeine addiction and my need for documents. I guess my caffeine habit and my document addiction. I like that phrasing a bit better. Over on YouTube, I've been uploading more videos, including the podcast, but also clips from the podcast, and I upload them as individual videos. If you're interested, go over there and give them a watch, give them a comment. On YouTube, it really helps your videos do better if someone comments on them. On Rumble, I do the exact same thing, same videos, and I also have the same playlist on Rumble and on YouTube for all the different cases I follow. On Rumble, it helps when you like a video. That helps it do better in the algos. I have noticed on YouTube that my Fulton County and 2020 election probe related content, the view numbers go up and then they go down, and then they go up and then they go down. Then they go back up. And Not by much, but there's some weirdness going on with any video I do that mentions the 2020 election. On Rumble, they just go and go and go. And who knows how many views on either one are real. I know my Substack subscribers are real, so thank you guys. All right. I've rambled a bit. Let me go over here. Hope you enjoyed the dog distraction. It's time for documents now. All right, so back in January of this year, as you probably know, the FBI raided a storage facility in Fulton County that contained 656 boxes, at least, of 2020 election related records. And they are original records that belong to the Fulton County Board of Elections. And they stored them in this facility. The FBI got a search warrant as part of a criminal probe into the 2020 election and criminality apparently that was happening in Fulton County. On this episode, I've done 2 videos on this already, and I've talked to you about how there's search warrants, there's subpoenas, there's at least 2 U.S. attorneys, Dan Bishop in North Carolina and Thomas Albus in Missouri, who have been tasked by the Attorney General of the United States with conducting an election probe concerning the 2020 election, a criminal probe. And after this, I've done those 2 videos you can find on the playlist on Rumble and YouTube. I've done a playlist that's titled like Fulton County election probe or something like that. Anyway, a week after that raid where the FBI took those 656 boxes, I think it is, of 2020 election records, Fulton County Board of Elections filed this lawsuit. It's called a Federal Rule of Criminal Procedure 41G. And that's for them to get the seat. It's the lawsuit that's filed when there's stuff has been taken by search warrant. And we talked about this in the Dan Richmond case, which is a really interesting case that had to do with Comey material. So this motion for return of property, all this was filed back on like a week after, on February 5th. And their argument, Fulton County's argument, was that the reason these 656 boxes should be returned, should be by court order, is that 1, the government showed callous disregard for the Fourth Amendment in their search warrant, and they violated the Fourth Amendment rights of the citizens of Fulton County and the Fulton Election Board. The other reason that they cite, and they explain each one of these in detail, I'm not going to go into it here because we're going to get into it later. They explain the callous disregard, or another reason they want to return is there's been callous disregard for state sovereignty, that DOJ violated state sovereignty in doing this. Callous disregard for the First Amendment, because this is intimidation, and it also violates the privacy rights of the citizens of the state. And they named Tulsi Gabbard and FBI Deputy Director Andrew Bailey being on site, and like, I don't know. They say that them being there was a move designed to intimidate Fulton County. And then that the remaining factors under 41G are that the petitioners have a clear interest in these original records, which the petitioners are Fulton County, and federal retention irreparably harms petitioners' sovereign function and the voters' privacy interest with no adequate alternative remedies. So based on those factors, they think the court should order DOJ to give all of these boxes back to them. So because this order was motion, I swear I know how to speak English. Because this was filed, the judge ended up putting in a standing order, and he ended up ordering DOJ to stop reviewing records until this is sorted out. And this has played out for months until May 7th, when the judge said, all right, I've decided that you don't get your 656 boxes back. DOJ is now clear of this case. This case is closed, and that means DOJ can start reviewing the records, which is what I talked about in my previous video on this. But I thought that it would be worth going through the judge's order. It is 68 pages. I may skip over some of it. But within his order, he gives a really nice background on how this has played out, what's going on with this election probe, what the search warrant's about, and the interest of all the parties. And then he arrives at his order. And I think this might give us some good insight. And it's a unique situation where a court has actually taken up a 2020 election issue and has reviewed it on the facts, which was a complaint a lot of us had back in 2020 that courts weren't doing. They weren't taking any 2020 election cases, and they were dismissing them or saying they're untimely filed or whatever, and none of them were taken on the facts. And so none of the evidence was ever reviewed. Well, here we have a situation where a judge has actually given it some attention. So I think this might cut through some of the BS. The other reason I want to go over this is I think this has legs. I very much think this Fulton County election probe has serious legs all the way up to the AG. And I think this is really going somewhere, is what I'm saying. So I think it's worth having this background and having this understanding of where it's at, both as a means of informing ourselves just for the sake of knowing that, but also as a means of guarding against all of the dis, and malinformation that is trafficked to both sides of the electorate, but particularly to MAGA's side. There's a ton of bad information and a ton of conspiracy slop that is trafficked to MAGA that has to do with Fulton County specifically and 2020 election specifically. And they take advantage of people's either gullibility or people's desire to see perceived wrongs righted. And they fleece MAGA both for their money and attention and clicks and views, right? So I'm really tired of that happening. And I think informing ourselves of what's actually going on in Fulton County will be a way of gaining some discernment and a defense against some of that slop and misinformation that so regularly comes our way. So this is going to take a while. This is going to be a long read. So you may want to grab a cup of coffee, maybe a snack. I feel like I should have taken a Benadryl because I just had my dog in my lap and now my nose is itching. So sorry about my sniffles all of a sudden. I just Hercules is well, he's very lovable. He's also a mess. Okay. Procedural history. On January 28th, 2026, after obtaining a search warrant signed by a United States magistrate judge, the Federal Bureau of Investigation seized over 600 boxes of Fulton County's 2020 election records. Soon after, on February 5th, 2026, petitioners filed an emergency motion for return of property pursuant to Federal Rule of Criminal Procedure 41G. Petitioners amended their motion on February 17th. After briefing closed and the parties attempted to mediate their dispute, the court held an evidentiary hearing on March 27th, 2026. Thereafter, petitioners filed a post-hearing motion for additional evidence. Although the court denied petitioner's motion, by the way, petitioner here is Fulton County. They're the ones trying to get the records back from DOJ, who's the defendant here. Although the court denied petitioner's motion, which sought to compel respondents in this case is DOJ, I should say, not defendant, compelled respondent to answer certain questions and separately requested documents for an in-camera review, the court determined that if petitioners obtained additional evidence, they could submit it to the court no later than April 27th. Petitioners timely submitted additional evidence, and that's document 98. In addition to submitting additional evidence, petitioners filed a motion to compel, which this court granted in part. The parties filed supplemental briefing on May 5th, 2026, and with evidence now closed and briefing complete, petitioners' amended motion for return of property is now ripe for review. The facts. After considering the party submissions and the entirety of the evidence, The court set forth the following facts, which relate to A, the 2020 election in Fulton County, B, current litigation involving 2020 election records, C, the FBI seizure of the election records, and D, pertinent testimony from the evidentiary hearing. All right, Part A, the 2020 election in Fulton County voting. In 2020, Fulton County voters could vote either absentee or in person. Given the COVID-19 pandemic that was still affecting the country at the time, many Fulton County voters chose to vote absentee. To vote absentee, a person had to request an absentee ballot prior to the election. The Secretary of State then sent the voter a blank absentee ballot and 2 return envelopes. Once the voter filled out the ballot and placed it in the provided envelopes, the voter would return the ballot either by leaving it in a designated drop box or by mailing it. Because 2020 ballots were placed in envelopes, they were typically folded. Perks my interest that he chose to mention that. Voters who did not vote absentee could vote in person during the early voting period or on election day. These voters cast their ballots on voting machines. After a voter made his or her selections using the machine's electronic interface, the machine would print a filled-in paper ballot with a QR code indicating the voter's selections. Completed ballots, whether cast in person or absentee, were electronically counted and recorded using tabulator machines. Relevant here, tabulator machines capture 2 types of digital records when scanning ballots. The first record is a cast vote record, which is the actual recording of a voter's selections that is ultimately used to tabulate the results of the election. The second is a picture of the front and back of the ballot, known as a ballot image. Ballot images are not ballots and are not used to tabulate the results of the election, but they are often retained as a form of receipt. In addition to capturing the digital records, tabulator machines contain a memory card that stores information about the scanned ballots, including the total number of votes cast for each candidate on that particular machine. The tabulator machines also have a protective counter, which logs the total number of ballots recorded on an individual tabulator machine during the machine's lifetime, similar to how an odometer keeps track of the total number of miles driven on a car. At the end of the voting period, poll workers generate tabulator tapes from the tabulator machines. A tabulator tape documents the number on a tabulator machine's protective counter, as explained above, the total number of ballots scanned by that tabulator machine during its lifetime, and the number of votes cast on that machine for each individual candidate. Tabulator tapes serve as a, quote, paper backup to the memory cards that store the ballot tabulation and are not part of the process by which official results are reported by counties to the Secretary of State. Under Georgia law, the tabulator tapes must be signed by the poll manager and 2 poll officer witnesses counting the votes. Okay, I got this pause right here. The fact he's going this granular with this and setting this stuff out gets me excited. Because I do think this election probe has legs. I think it has criminal legs. We're headed to a criminal indictment of someone at some point, or someone's. And these being the factual things he's laying out, this is what we're going to be talking about when that indictment, or some of what we're going to be talking about whenever that indictment comes. After the polls closed on election day, Fulton County began counting ballots. In 2020, as summarized in Figure 1 below, 3 separate counts occurred before the results were certified. The first count, which is we're going to call the original count, began immediately after the polls closed and was completed the following day. Fulton County used tabulator machines during the original count to keep track of the votes electronically. After the original count, Fulton County conducted a second count, the risk limiting audit. Voters and members of the public performed the risk limiting audit by hand counting the ballots. The purpose of the risk limiting audit was to detect or determine whether or not there was sufficient evidence that the outcome of the original count was incorrect. Because the purpose of the risk limiting audit was to determine whether there was confidence in the original count, the results of the risk limiting audit were not certified, nor were they a precise count. In early December 2020, a third count, called the recount, of the ballots occurred. Like the original count, the recount utilized tabulator machines to electronically scan the ballots. Ultimately, the results produced in the recount were certified as the official election results for the 2020 Fulton County general election. I'm going to pause right here and interrupt again and say, I'm game for wherever this leads. I am game for whatever the facts and evidence shows. Whether it shows something I already think happened, like if we find evidence of what I already think went down there, that's great. But if we find evidence here that contradicts what I have been led to believe, or what I've discerned, or what I've speculated, or what I've bought into, however you want to think of it, about what happened in Fulton County in 2020, I'm game for that too. I'm game for wherever the evidence leads, whether it confirms something I think or invalidates something I think. And I hope you guys will join me in that, because like I said earlier, I'm tired of being fleeced. I'm tired of being misled. I'm tired of being grifted upon. I just want to freaking know what the evidence says. And that's it. All right. November 2020 election, Fulton County ballot counts. Method: tabulator machines, hand count, tabulator machines. Nice. We got a little Excel box here. Great. All right. Tiny little spreadsheet box. All right. Investigations and reports concerning the 2020 election. Given the closeness of the 2020 election and concerns by some that it was not conducted in a fair manner, there were multiple investigations into Fulton County's election process. Following these investigations, Seven Hills Strategies, LLC, the Fulton County Performance Review Board, and the Secretary of State issued reports. The reports are discussed below. The Georgia State Election Board, which it's going to call SEB, so we need to remember that's the State Election Board, contracted with Seven Hills Strategies to serve as an independent, nonpartisan monitor for the 2020 election in Fulton County. In its report, Seven Hills Strategies identified several problems with the election, like the extremely sloppy absentee ballot counting process. While the report acknowledged that the election was not perfect, the report noted that there were no indications of, quote, dishonesty, fraud, or intentional malfeasance by any Fulton County election officials. In 2023, the Fulton County Performance Review Board issued a report concerning elections in Fulton County. In its report, the Performance Review Board summarized previous investigations into the 2020 election and agreed with the Seven Hills Strategies report that there were no indications of fraud, dishonesty, or intentional malfeasance by election officials. The report also stated that elections conducted in 2021 and 2022, which are not an issue here, ran smoother than the one that occurred in 2020. The Secretary of State issued reports in 2022, 2023, and 2024. These reports address specific complaints about the 2020 election. The first report, released in 2022, discussed the risk limiting audit. The report recognized that irregularities occurred with the risk limiting audit and determined that they were caused by human error and issues with Fulton County's data reporting. The 2023 report addressed allegations of mishandled ballots and found that there were no violations of the law. The final report pertained to alleged problems with ballot images and tabulator tapes. As to these problems, the report found that there were possible violations of SEB, so State Election Board, rules relating to the counting process. Right, current litigation involving 2020 election records. The 2020 election led to multiple civil lawsuits. At least two of those suits are still pending, and petitioners claim that they are relevant here. The suits are Allen v. State of Georgia, filed in the Superior Court of Fulton County, and the United States v. Alexander case, which is filed in the United States District Court for the Northern District of Georgia, which is the same district this lawsuit is in. So we have the Superior Court action, which is Allen v. State of Georgia, and we have United States v. Alexander, which is the federal court action. Both actions were stayed after the FBI seized the election records. The court discusses the Superior Court action first. The Fulton County Board of Registration and Elections, which is BRE, Fulton County Board of Registration and Elections, who brought this suit because it was their records that were raided, filed the Superior Court action in November 2024 seeking to quash 2 subpoenas issued by the State Election Board for the 2020 election materials. That's the Allen case. On October 6, 2025, the State Election Board issued a new subpoena, which the Fulton County Board also sought to quash for, quote, all used and void ballots, stubs of all ballots, signature envelopes, and corresponding envelope digital files from the 2020 general election in Fulton County. The Superior Court denied the motion to quash on December 22, 2025, and ordered Fulton County's Board of Elections to provide the materials to the State Election Board upon payment of production cost. The Attorney General of the United States filed the federal court action on December 11, 2025. In the federal court action, the Attorney General sued Che Alexander, who's the clerk of Fulton County, seeking the same materials that the State Election Board requested in its October 6, 2025 subpoena. The Attorney General sought access to the records via a federal statute that requires custodians of election records to, upon written demand, make their records available for inspection. I'm sorry if y'all are hearing my dogs barking upstairs and hearing Hercules going crazy because he's not up there with Athena barking. No, you can't join her. Nope. You're going to stay with me. Make their records available for inspection. Okay, so just to be, you guys understand, the 2 civil actions that were going on is the State Election Board sent subpoenas to Fulton County saying we need to take a look at the 2020 election records, the original records. And a court agreed, yep, you need to comply with that subpoena. And then DOJ filed a lawsuit saying, yeah, we need to take a look at those election records for 2020. That's Harmeet Dillon and the AG, right? Shout out to Harmeet Dillon. The Attorney General wanted to access those records, and that one wasn't resolved. I don't think the court ever resolved that one. On January 5th, the clerk filed a motion to dismiss it. But then, shortly after, this criminal probe started up, which led to the FBI's raid. So these 2 other cases, the Superior Court one and the Federal District Court one, those are civil actions. Those are not criminal ones, but they're concerning the exact same materials. The exact same materials that the FBI then seized. The criminal investigation in this case originated with a referral from Kurt Olson, the presidentially appointed Director of Election Security and Integrity. I'm going to pause. So Kurt Olson has appeared at various times with some of the 2020 election stuff. I remember him from Arizona. I remember him from some other cases that he's been a part of. I don't remember if he brought them or if he was just if he was hired onto them. Right now, okay, I was positive on Kurt Olson. I had a positive opinion. But over the past 1 to 2 years, really 2 years, I've moderated on that. And everybody involved with 2020 election stuff is either neutral to me or I've decided I ain't got time for you. Or worse. I'm just there's just way too much junk. They've trafficked, they've peddled, they've grifted off of way too much junk. They've sold empty, like those Russian dolls, those nesting dolls, to me, and I'm tired of it. I'm tired of the bad information. I'm tired of the speculation. I'm tired of the promises. Um, I'm tired of it. And either you're neutral with me, and I'm just like, you know what, I think you were trying to do a good thing and got caught up in it just like I did, and now we're both the wiser for it, hopefully. Or I think you're a shyster. And with Kurt Olson, I've gone from positive, favorable view of him to I'm just neutral. I'm just neutral. I can't name anything specifically where I'm like, I don't like him, or anything I think he was involved in where I'm like, that wasn't credible. Um, but I also can't like point to something where I'm like, bam, that guy did great work. Now, maybe I've just missed it. But it's nothing personal against him, and it's nothing really specific against him. It's just that my standards have gone up. That's really what it is. My standards I've raised my standards. That's all. All right. Specifically, no later than not. So this is really interesting because the criminal investigation originated with a referral from Kurt Olson, who Trump appointed to the Director of Election Security and Integrity position, which he created. All right, specifically, no later than 9:03 a.m. on January 5th, 2026, which is the same day the clerk for Fulton County filed a motion to dismiss the federal action seeking these 2020 election records, which DOJ has lost on a lot of these. DOJ has sought election records from a number of states, like a dozen or something, and they've been on a losing streak with getting access to these voting records. And actually, I have no opinion of whether or not they should be or they shouldn't be. I don't really know. I'd have to look at those cases and see. I really don't know. Maybe they should have lost those cases. Maybe they shouldn't have. Maybe they should have filed a better lawsuit. Harmeet Dillon's pretty good. I have a positive opinion of her. So my faith continues to remain with her. I'm not sure. I'm just going to put sign that as undecided whether or not DOJ should or should not have lost those cases. Okay. So same day, this referral happens. Thomas C. Albus, the United States Attorney for the Eastern District of Missouri and Special Attorney to the Attorney General, received the referral on January 5th, 2026. The next day, the FBI opened an assessment. Shortly thereafter, on January 12th, 2026, Special Agent Hugh Raymond Evans, who's going to be referred to as S.A. Evans, so Special Agent Evans, an FBI agent assigned to the Public Corruption and Civil Rights Squad, requested that the matter be opened as a full investigation, and his request was approved on January 14th, 2026. So bingo, right there, that tells you the nature of the crime or crimes they have probable cause to investigate. It's going to be a public official, and it's going to concern violations of someone's civil rights. Most likely, anyway, you can infer that. One or both of those things, because that's the type of investigation agent that they're pulled onto it. And his request was approved on January 14th. On January 19th, 2026, Special Agent Evans began drafting his investigative summary based on witness interviews, which he converted to the format of a search warrant affidavit on January 22nd, 2026. On January 27th, 2026, Albus submitted a search warrant application to the magistrate judge seeking permission to seize Fulton County's 2020 election records. The court first discusses the search warrant application before turning to the execution of the search warrant. All right, the search warrant application. As part of the search warrant application, Special Agent Evans provided an affidavit for the purpose of establishing probable cause. The affidavit stated that the FBI was investigating irregularities in the 2020 election in Fulton County. The affidavit is specifically focused on missing ballot images, duplicate ballots, tabulator tapes, pristine ballots, and issues with the risk limiting audit. So, by pristine ballots, that makes me think of absentee ballots that were never folded. Special Agent, this is a footnote. In the affidavit, Special Agent Evans also noted a problem with the reported recount numbers. Specifically, Special Agent Evans stated, quote, on the day of the deadline to report the recount results, Fulton County reported a recount totaling 511,343 ballots, which is 17,434 ballots fewer than originally counted. The following day, Fulton County then reported a total of 527,925 ballots counted. The affidavit never again mentioned any problem with the number of ballots tallied in the recount. While the affidavit only mentioned this issue in passing, the court does have concerns that the statement was misleading. Okay. Missing ballot images. Special Agent Evans stated in his affidavit that the FBI was investigating missing ballot images. As noted previously, a ballot image is a digital scan of a voter's completed ballot and is automatically created when a ballot is fed into a tabulator machine. Pause. I'm looking to see if my dog registers on the mic. I'm sorry if you can hear the dog upstairs barking, but I think we have an Airbnb nearby, like across the street. So I'm guessing there's probably somebody pulled up and they're unloading and she's letting them know that this is her neighborhood and you don't mess with her. So that's the type of bark she's doing. It's not her cat bark. There's a cat that's a totally different bark that she does for the cat, and it's not her bark that she does for the mailman or the UPS driver or Amazon. Those are different. This is I'm here, witness me bark. that's what it is. Okay. In the affidavit, so again, I'm just sorry if that's distracting. All right. In the affidavit, Special Agent Evans reported that there were almost 18,000 missing ballot images from the recount. According to Special Agent Evans, the director of elections for the Georgia Secretary of State told him that a discrepancy like that would be problematic. Special Agent Evans also provided information that some of the ballot images appeared to have been modified or manipulated as recently as January 11th, 2024. Could that be simply from them being opened and looked at and then resaved or transferred from devices? The FBI will be able to tell. The FBI will be able to pick apart, literally bit by bit, what's been done with these images. Although Special Agent Evans did not fully explain the importance of ballot images or the significance of missing ballot images, he did acknowledge that the images are just duplicates and that it was only the actual ballots that were counted to determine the winner of a given race. The concern is less about the images, he said, and more about the ballots and voter count. And when the Secretary of State conducted the recount, they did not focus on the images taken by the scanners. They took the actual ballots that were cast and counted them one by one to come up with the total. Special Agent Evans further acknowledged that a possible explanation for the missing images was that they were stored on a memory card and it was not uploaded correctly or became corrupt. Okay. I seem to remember some stories about the storage devices getting wet, storage devices not being stored properly, not protected from the elements. Okay. In the affidavit, Special Agent Evans indicated that the FBI was investigating duplicate ballots which were detected by, quote, stray marks or other unique markings on a ballot that would allow it to be uniquely identified. Special Agent Evans explained that a witness told him that he discovered duplicate ballots in both the original count and the recount. In addition to the duplicate ballots, the witness also informed Special Agent Evans that he found new ballots and test ballots in the recount that did not appear in the original count. Okay. In the witness's opinion, the addition of these duplicate or new ballots did not change the outcome of the election, but could have been an intentional act to make the recount match the original count. Special Agent Evans noted that if deliberate, this type of ballot manipulation would be an intentional tabulation of ballots in a false manner in violation of the law. You know, if all that comes of this is that they find evidence to criminally indict people who did something like that, you know, that clears up something. That helps explain some of what some of our concerns. And it's also accountability for some of the concerns, right? I'll just leave it at that for now. All right. After detailing these potential concerns regarding duplicate ballots, Special Agent Evans disclosed that the Secretary of State investigated the issues and closed its investigation after learning that the duplicate ballots favored Donald Trump. So let me back up. After detailing these potential concerns regarding duplicate ballots, Special Agent Evans disclosed that the Secretary of State investigated the issue and closed its investigation after learning that the duplicate ballots favored Donald Trump. Hmm. Hmm. Footnote. Indeed, the duplicate ballots appeared to favor Donald Trump. The witness concluded that what he observed could be intentional but was not partisan because by adding the duplicate ballots, Donald Trump received approximately 10% more than his average in Fulton County, so 40% instead of 30%. There are some swampy Republicans in Georgia, and I am of the opinion that the GOP establishment also rigged. GOP establishment also engaged in sus things during the election. I'll say that. I am very bipartisan, but yeah, I am very bipartisan on my distrust of the establishment on both sides, and both sides' willingness to mess with things. All right. Special Agent Evans further explained that the Fulton County Director of Registration and Elections admitted that duplication of ballots may have occurred, but indicated that if it did occur, it happened due to human error, which is totally believable. But at some point, if it happens so much, it seems less like human error and more like human intention, right? This really makes me wonder if somebody did that intentionally to try and frame Trump, which I've always thought. I've always thought that there was a lot of framing of Trump going on in the 2020 election stuff. Special Agent Evans also included a discussion of tabulator tapes in the affidavit. As previously explained, tabulator machines print tabulator tapes after the polls close at the end of the voting period. The tabulator tapes reflect the number of total ballots scanned or a given tabulator machine, as well as the number of votes cast for each individual candidate on that machine. Special Agent Evans explained that he spoke with a witness who reported that some tabulator tapes from the 2020 election were not properly signed, as required under Georgia law, and that this deficiency impacts the accountability process. The same witness told Special Agent Evans that the tabulator tape should match the number of physical ballots scanned by that machine and described tabulator tapes as the holy grail for the final count. The affidavit also referenced a December 9th, 2025 state election board meeting during which Fulton County stated that the tabulator tapes accounting for 315,000 ballots were not properly signed. According to the affidavit, Secretary of State Brad Raffensperger told the media that he considered this error to be an administrative oversight. Just to clarify my thing about thinking the GOP establishment tried to frame Trump, what I mean by that is Jordan Fuchs, or whatever her name, however you say her last name, Jordan Fuchs and Brad Raffensperger attempting to frame Trump, and others attempting to frame Trump. And also Steve Bannon and his crew. But I've gone into that on other episodes. I won't go into it here. All right. With regard to tabulator tapes, Special Agent Evans included several observations from Clay Perrick, a cybersecurity specialist with experience running security and performance checks on voting equipment, and a current special government employee appointed to work for the executive branch. I remember that name, Clay Perrick. I didn't know he was working for the executive branch right now. Interesting. After reviewing tabulator tapes that he obtained through an open records request, Perrick suspected that memory cards were removed from some tabulator machines and inserted into other tabulator machines, meaning that certain tabulator machines were used to generate final tabulator tapes reflecting a voting data gathered from several tabulator machines. Perrick arrived at this conclusion after determining that closing tabulator tapes from some machines were missing, and of the 138 tabulator tapes reviewed, it appeared that 16 tabulator machines were utilized to produce the tapes for approximately 315,000 ballots. For instance, Perrick identified one tabulator machine that was used to generate tabulator tapes for ballots scanned on 16 total tabulator machines across 12 different locations. Presumably, this occurred by taking the memory cards from 15 different machines and feeding them all into one separate tabulator machine that generated a tabulator tape reflecting data at the end of polling from both that machine and the 15 other machines. Based on the proximity of the times reflected across several tabulator tapes, Perrick further reported that he believed that someone had manipulated the poll closing and report printed times on several tabulator tapes. Perrick also reviewed the protective counter data reflected on the tabulator tapes. Again, protective counters depict the total number of ballots scanned by a given tabulator machine during the machine's lifetime. Perrick determined that the protective counter numbers on 5 separate tabulator tapes from the same tabulator machine were identical, and that for some tapes, the ballot scanned number exceeded the protective counter number, which of course can't happen. In Perrick's view, this indicated that no ballots were ever actually scanned on these tabulator machines, but rather the tabulator tapes were printed on the machines by inserting a memory card from a different tabulator machine and printing a tape based on the foreign memory card's data. The affidavit concluded, again, this is all from the affidavit, that this would have allowed an opportunity for the tabulation to be tampered with. After his discussion of Perrick's findings and conclusions, Special Agent Evans included in the affidavit statements from a different witness asserting that the tabulator tapes were not used to determine the final vote. In fact, this witness reported that the tabulator tapes from the original count were not needed during the recount because the ballots were rescanned using a different tabulator machine. According to the witness, the ballots were what mattered. Right? Pristine ballots. The affidavit provided that the FBI was investigating pristine ballots, which Special Agent Evans described as absentee ballots that have no indications that they have been folded and mailed as a typical absentee ballot would. At the outset, Special Agent Evans explained that the state election board member told him that, quote, there is no reason to have a pristine absentee ballot with no folds. The affidavit then described claims about pristine ballots made by a 2020 poll manager. I'm sure many of us easily recall that. This witness stated, I wonder if it's the same one. There's probably more than one. But this one for this affidavit, this witness stated that during the risk limiting audit, she saw ballot boxes with broken seals, unfolded ballots, and some stacks of ballots that were located outside of the view of security cameras. She described one box in particular that included 110 absentee ballots. According to her, these ballots lacked folds and were too clean to be absentee ballots. Additionally, she said that 107 of these pristine ballots were identical, voting for the same candidates in every race. Finally, she thought that these ballots had a different texture from typical ballots. The affidavit also mentioned that another witness who assisted with the risk limiting audit likewise remembered the 107 ballots and said that the selections looked like they had been made with a stamp. All right, by the way, the FBI will be able to tell whether the paper is the same paper, whether the ink is the same ink, whether it's stamped or it's handwritten. They'll be able to get down to the microscopic level and look at pen strokes, the actual fibers of the paper, how the fibers go together. They'll be able to just like scientists. They'll be scientists with these ballots, and they'll be able to determine whether or not what this lady is saying actually is valid or not, or they'll find another explanation for it. But this is the kind of stuff that the FBI has the equipment and technical know-how to break down and discern exactly what's going on there. This same witness reported that she saw two individuals re-voting ballots printed on a different kind of paper and was told by the then director of elections for Fulton County that these individuals were re-voting the ballots because the originals were not accepted by the machine. Special Agent Evans noted in the affidavit that under Georgia law, any duplicated ballots or of damaged or unscannable original ballots had to be clearly identified as duplicates. Additionally, the affidavit discussed statements from a current Fulton County commissioner who was a poll worker during the November 2020 election. This witness was assigned to test ballots on tabulator machines to make sure that the machines were working accurately. While performing these tests, the witness said that she observed stacks of unsecured test ballots, unattended ballots that had been already cast by voters at early voting locations, and the printing of random ballots, even though all of the necessary test ballots had already been printed. While Special Agent Evans detailed the concerns that these witnesses had with the pristine ballots, Special Agent Evans explained that the Secretary of State's election director did not think that it would be feasible for someone to tamper with absentee ballots due to how many people are in the room, and that it would be barely possible to do anything on a large scale. I mean, fair enough that some of the allegations would have required some pretty large scale efforts that strain believability. Special Agent Evans also noted that the election director told him that there would be pristine absentee ballots in every election because the vote review panel would generate a pristine ballot after adjudicating the result of a damaged ballot. See, that's a perfectly understandable explanation for the existence of pristine ballots. That the original that was mailed, that was folded and mailed, was damaged, and so a pristine one was generated on the spot so that the vote represented on the damaged one could be scanned by a tabulator. That makes complete sense. That's an example of where something you see makes you suspicious, but then when you get the full explanation of it, it's, now I understand why that's the case. So how many times did that happen? Do we have them matched up to make sure that each pristine ballot also has a corresponding damaged ballot to go with it, right? Special Agent Evans further reported that the election director stated that if fraudulent absentee ballots were introduced during the reconciliation process without removing real ballots, it would be caught by comparing the total number of ballots to the total number of votes. The election director also said that he was not aware of any discrepancies between the voter count and the ballot count. There's a footnote on that. The affidavit also included statements to the same effect from another witness. This witness, an investigator with the Secretary of State's office, explained that the provisional ballots available on Election Day were all accounted for. Even though the election director opined that it would not be feasible to introduce fictitious ballots on a large scale, he did note that there was no way to determine whether someone substituted fictitious ballots for real ballots during the reconciliation process if the voter total and ballot total matched. Special Agent Evans further included a statement from an investigator with the Secretary of State's office indicating that he did not know how a person could inject fraudulent absentee ballots into the count, and indeed that a post-election ballot count performed by the Georgia Secretary of State's office and the recount performed by Fulton County matched. The risk limiting audit. The affidavit also raised issues with the risk limiting audit conducted by Fulton County. As already discussed, the risk limiting audit was not an official recount, but was a tool to verify election results. Special Agent Evans stated in the affidavit that a witness identified 36 errors within the batch tallies, and that these errors included duplicated or misidentified batch entries, and incorrect batch entries reflecting 100% vote for one candidate, which, of course, is highly suspicious. In contrast, Special Agent Evans also included in the affidavit the statements of one witness who believed that the ballots were all accounted for during the risk limiting audit. So, different people saying different things, that provides a good reason to go have a look and see which one is correct. Special Agent Evans explained in the affidavit that reports from the Seven Hills Strategies and the Performance Review Board confirmed that there were problems with the risk limiting audit. Specifically, the Seven Hills Strategies report stated that, quote, there were a chain of custody issues, ballots left unattended, unsealed bags being used, and auditors not recording seal numbers on ballot bags. The Performance Review Board likewise found that there were inaccurate batch tallies. Special Agent Evans disclosed in his affidavit that both reports concluded that there was no, quote, no evidence of fraud, dishonesty, or intentional misconduct with regard to the November 2020 election in Fulton County, but rather persistent disorganization, quote unquote. Which, one, if there was fraud, dishonesty, and misconduct, there also being persistent disorganization would make it difficult to suss that out, right? But also, if there wasn't fraud, dishonesty, and intentional misconduct during it, that same persistent disorganization would also make it appear as if there was those things, right? So this right here, if it exists, cuts both ways, right? Okay. Other observations in the affidavit. In Special Agent Evans' view, the above irregularities, if intentionally caused, demonstrate violations of 52 U.S.C. 2701, 20701, and 52 U.S.C. 20511 2B. Section 20701, which is a records retention statute, provides that, quote, every officer of election shall retain and preserve for a period of 22 months from the date of any general, special, or primary election of which candidates for the office of president are voted for all records and papers. But more simply, the statute requires election officers to retain election records for 22 months. Section 20511 2B states that it is a felony to, quote, knowingly and willfully deprive the residents of a state of a fair and impartially conducted election process by the procurement, casting, or tabulation of ballots that are known by the person to be materially false, fictitious, or fraudulent under the laws of the state in which the election is held. Essentially, Special Agent Evans stated in his affidavit that the seizure of the election records could show that some of them were intentionally destroyed, or that the tabulation of votes included materially false votes, either through duplicated scanning of specific ballots or through the interjection of pristine ballots. Which, we always tend to think of these things in the terms of Trump v. Biden, but those aren't the only people on the ballot. Other people who would benefit from false votes through duplicate scanning and the interjection of pristine ballots are people down ballot from Trump and Biden, right? They also stand to benefit or lose out. So just keep in mind that the motivation for, if this was happening and it was criminal, the motivation for what they were doing may have nothing to do with the guys on the top of the ballot. It may have everything to do with the state level and county level people on the ballot. That's a possibility that doesn't get a lot of attention, right? Because everybody thinks it has to do with Trump or Biden. There's some huge grand conspiracy. But there doesn't have to be. It can be someone much further down the ballot who's very interested in putting someone in power or keeping someone out. Swamp, 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 right? Execution of the search warrant. The magistrate judge considered the search warrant application on January 28th, 2026, and determined that there was probable cause. This has caused many people to be upset. Consequently, the magistrate judge signed the warrant authorizing the seizure of the election records. After the warrant was signed, FBI agents executed the warrant and seized over 600 boxes of election records. Following the seizure, both the Superior Court action and the federal court action, remember those, were stayed, which means paused, because at least some of the items at issue in those cases were no longer in the clerk's possession. Pertinent testimony from the evidentiary hearing. The court conducted an evidentiary hearing on the petitioner's amended motion for return of property on March 27th, 2026. At the hearing, petitioners' evidence primarily focused on what they perceived to be shortcomings with Special Agent Evans' affidavit. Specifically, petitioners argued that Special Agent Evans omitted material facts from the affidavit that, had they been revealed to the magistrate judge, would have caused her to deny the warrant application. Petitioners called an expert witness, Ryan Macias, to testify regarding the affidavit's alleged deficiencies. Macias opined that the affidavit omitted various innocent explanations for the facts that it alleged, which, for a number of these things, we already talked about how there could be innocent explanations for them. For instance, he asserted that pristine absentee ballots that do not have folds are normal in elections, especially from military and overseas voters. As to one witness's description of ballot images filed that were modified after the date of the election, Macias explained that the Secretary of State's office might have renamed ballot image files, which would result in a later modification date. That makes perfect sense. I'm looking at these footnotes. Macias's written declaration was admitted into evidence at the hearing. and he provided that he was, quote, an election technology and security expert. Addressing the affidavit's discussion on tabulator tapes, Macias confirmed that memory cards were taken from some machines and then, after Election Day, input into different tabulator machines to determine the final vote count. Macias explained that this was done specifically with tabulator machines used during early voting so that the election officials did not have to send personnel back to each early voting location after the close of voting to retrieve the votes from those machines. Macias stated that the memory cards were stored securely until Election Day and were then used to generate tabulator tapes reflecting each memory card's results after the close of voting. Macias explained that this was done because it is impermissible to begin calculating election results until all votes have been cast, and that nothing in this process indicates misconduct. Macias also discussed other aspects of the affidavit. He testified that ballot images and tabulator tapes have no bearing on the election outcome because only ballots are counted in determining the winner of a given race. He further testified that the sort of issues identified in the affidavit occur in virtually every election. And I can believe that. I can believe that with the innocent explanation, some disorganization, some mistakes, human error. But how many times does it need to occur or appear to occur before you start saying, okay, are these all really human error? Is there this many pristine ballots normally? Should there be? The 2020 was a really weird year. So there could be completely innocent explanations for all of it. And I'm telling you, I'm willing to accept that. And then really be happy about it, because I would much rather believe that our elections are way more secure than I've been thinking for the past 5 years. Isn't that preferable? Isn't it preferable that we find out actually things are much better than our impression? That'd be great. That's not exactly where I'm at, but I'm willing to accept that. This depends on where the evidence goes. I'm willing to accept where the evidence goes. All right, discussion. Petitioners assert that under Federal Rule of Criminal Procedure 41G, the court should order the immediate return of the seized property. Rule 41G permits, quote, a person aggrieved by an unlawful search and seizure of property or by the deprivation of property to move for the property's return. Whereas here, a party invokes Rule 41G before the initiation of any civil or criminal proceedings, the motion for return of property is treated as a civil action in equity. Notably, the 11th Circuit Court of Appeals has held that a district court should invoke its equitable jurisdiction only under the narrowest circumstances, and that exercises of equitable jurisdiction should be exceptional and anomalous. And guess what? That's another Trump-related case from 2022, when he sued for the return of his property after Mar-a-Lago, I believe. I believe that's what that case is. I'm pretty sure it is. All right. In other words, a district court should show caution and restraint before exercising its equitable jurisdiction. Courts are required to apply the exacting test when deciding whether to exercise equitable jurisdiction over suits flowing from the seizure of property. Under this test, courts must consider 4 factors called the Ritchie factors. 1, whether the government displayed a callous disregard for the plaintiff's constitutional rights. 2, whether the plaintiff has an individual interest in and need for the material whose return it seeks. 3, whether the plaintiff would be irreparably injured by denial of the return of property. And 4, whether the plaintiff has an adequate remedy at law for the redress of its grievances. I remember these coming up in the Mar-a-Lago raid suit because Trump was trying to get like Celine Dion CDs back. Was one of the items named. He had an immediate need for his signed Celine Dion memorabilia or something like that. There were a few items that were pretty funny. I think it was Celine Dion. I remember laughing about it on this show. There were some other items that they were like memorabilia, like golf hats and shirts and uh, some other things that were seized in the boxes. It was pretty funny. All right, the purpose of this exacting test is to prevent unnecessary judicial interference with the executive branch's criminal enforcement authority, while also offering relief in rare instances where a gross constitutional violation would otherwise leave the subject of a search without recourse. It may not have been Celine Dion specifically, but it was somebody like that. It was a female singer. I want to say it was Celine Dion, but I could be mistaken. Anyway, callous disregard for constitutional rights. As stated above, courts should first consider whether there has been a callous disregard for a movant's constitutional rights. This factor is the most important of factors. Indeed, if the callous disregard factor is not satisfied, courts will not intervene in an ongoing investigation, and rightly so. Importantly, to ensure that equitable jurisdiction remains extraordinary and to prevent a flood of disruptive civil litigation, the callous disregard standard presents a formidable burden to movements. So the petitioners, Fulton County, or anybody else, and this that's Lindell versus United States, when Lindell sued to get his phone and devices back after they've been seized pursuant to a search warrant. So this makes sense. This, there would be a flood of disruptive civil litigation. What they mean is that, and what's easy to understand here, is that if it was so easy for someone who had been subject to a search warrant to get their property returned to them, then every single criminal would immediately file this type of suit to try and get whatever stuff was seized by a search warrant returned to them. And you can imagine how, with how many search warrants are executed against so many people, either written search warrants or search incident to whatever, a tow, or I can't remember the other name for it, when you search someone because like you have probable cause at that moment, or you have a reason to search them, whatever it's called. There would be endless. That's all the courts would deal with, was people filing lawsuit for return of property that was taken. And there has to be this high standard, because otherwise it'd be impossible for search warrants to function and to serve their purpose as a means of gathering evidence. So Fulton County, there's a high bar that they have to get to in order to get their stuff back, and they didn't meet it, of course. Although callous disregard is the most important factor, the 11th Circuit has not explicitly defined it. Helpful guideposts have been established, however. For example, the Ritchie Court suggested that a movement generally cannot establish callous disregard where the government's seizure of property was pursuant to a search warrant, even when the search warrant is subsequently challenged as invalid. Given this guidance, the 11th Circuit has recognized that, quote, the vast majority of subjects of search warrant have not experienced a callous disregard of their constitutional rights. That's another Trump case. Importantly, or it might be Mar-a-Lago, same one. Importantly, the court has not said that a movement's constitutional rights can never be callously disregarded when there is a warrant. Indeed, it would be error to find that no callous disregard exists merely because there's a warrant. Although the Ritchie Court suggested that a movement ordinarily does not meet its burden where the government seizure of property was pursuant to a search warrant, that court did indicate that a movement may be able to establish callous disregard where the government agents employ, quote, fraudulent or deceitful methods in order to gain access to a citizen's private papers. Okay. So they lie about what they witnessed or smelled, or there's something planted that leads to a search of the entire vehicle or home, or they say that a witness said something. With these guideposts in mind, the court analyzes petitioners' arguments. Petitioners advance two arguments in support of their contention that callous disregard existed here. First, petitioners assert that the affidavit lacked probable cause and omitted material facts. Second, petitioners contend that the manner of the execution of the warrant was unreasonable because it interfered with both state sovereignty and ongoing legal proceedings, and was premised upon criminal violations where the statute of limitations has already lapsed. That's pretty interesting, right? The statute, even if there was malfeasance here, the statutes they're citing here as the crimes they're investigating that they have probable cause to believe occurred, the statute of limitations has lapsed on those. So they can't bring those charges anyway. Which is why I think conspiracy is the name of the game here. There has to be a conspiracy. There has to be a conspiracy charge. A conspiracy to elect or not elect someone. A conspiracy to cover up a bunch of human error. Something related to public corruption, I think. The court addresses the arguments below. Petitioner's argument that the affidavit lacks probable cause and omitted material facts. The affidavit used to support the search in this case was 18 pages long and identified various alleged election deficiencies that the FBI was investigating. As stated previously, the affidavit provided that if the election deficiencies were the result of intentional action, it would be a violation of federal law. In petitioner's view, the affidavit failed to sufficiently allege intent. Specifically, the petitioners claim that the affidavit's hypothetical does not establish probable cause, and that the magistrate judge made a mistake of law in finding otherwise. The petitioners argued that the affidavit does not identify a single piece of evidence from the FBI's investigation establishing probable cause to believe that anyone intentionally, let alone willfully, violated the law. Ultimately, petitioners assert, quote, that it's woefully deficient for an affidavit to say, if I develop additional evidence at some point later in time, the seized property would potentially be evidence of a crime. In response, respondent, meaning DOJ, primarily asserts that the affidavit does not need to contain evidence of each element of the offense, including intent, to establish probable cause. The court disagrees with petitioner's argument that the affidavit is woefully deficient just because, in their view, allegations of intent are lacking. Indeed, an affidavit need not establish every element of a suspected crime. Imagine that. The cops don't have to have it all figured out before they issue a search warrant. Of course they don't. It need only present a fair probability that evidence of criminal activity will be found in the place to be searched, such as they come upon a vehicle and they smell cannabis, and they also see a bunch of little baggies in the car. And a big backpack that looks stuffed. There's probably some criminal activity going on there, which it shouldn't be because cannabis should be completely legalized everywhere. All right. Moreover, even if the affidavit did lack probable cause, I hate using that example because my belief on cannabis, but it is easily understood. All right. Moreover, even if the affidavit did lack probable cause because of a failure of the alleged intent, petitioner's argument hinges on the idea that a lack of probable cause equates to callous disregard. It doesn't. But petitioners do not offer any authority for this proposition. And in view of other cases' discussion of callous disregard, the court declines to adopt a rule here. So they're going to fail the first hurdle, which means the rest of them almost don't even matter, right? Because this is the most important, as we discussed earlier, this is the most important thing. Simply put, petitioners must do more to establish callous disregard. Footnote, as to the tabulator tape, Special Agent Evans reported that a witness thought that someone had manipulated the times on the reports because the poll closing time and the reported printed time were too close together. So if you take that in another situation, that's like so-and-so said that the suspect told them they were at this location and then they went to this other location. But the time they said they were at those don't line up. Like they said they were at the bar at 8:30 and then they left the bar at 8:45 and were home by 9 o'clock. But it's very clear that their home, the distance between the home and the bar would take longer than 15 minutes. Or it should only take 15 minutes, but they didn't get back home until 10 p.m. That's even better. So, like they say, I was thinking about too close together. Let's say it's too far apart. The person reported a witness said the suspect told them that they left the bar at 8:30 p.m. and got home at 10 p.m., but their home and the bar are not an hour and a half apart. They're only 15 minutes apart. Where were they during that hour and a half? There, it's analogous to that. All right, omission of material facts. Petitioners next argue that their rights were callously disregarded because the affidavit omitted material facts. In petitioners' view, these omissions misled the magistrate judge, whom they contend would not have issued the warrant if the omitted information had been included. Petitioners specifically focus on omitted facts related to pristine ballots, missing and duplicated ballot images, tabulator tapes, and the biases of the witnesses interviewed by Special Agent Evans. The court will summarize these alleged omissions in turn. As discussed previously, the affidavit stated that the discovery of pristine ballots during the risk-limiting audit showed that some type of wrongdoing may have occurred in the 2020 election. Petitioners argue that the affidavit is incomplete or misleading because pristine ballots are a typical feature of elections, and that they can occur because military members and other overseas other voters, cast ballots in a different manner than Georgians voting from within the state. That makes sense. They further assert that the affidavit is misleading because it omitted any reference to the Georgia Secretary of State's investigation, which found that the same pristine ballots claim was unsubstantiated. What if you can't trust the Secretary of State's investigation because the Secretary of State is involved in the conspiracy because he directly benefited from it? Just throwing that out there. Just throwing that out there. It's a possibility. Petitioners go on to address the affidavit's assertion that, quote, on the day of the deadline to report the recount results, Fulton County reported a recount totaling 511,343 ballots, 17,434 ballots fewer than originally counted. The following day, Fulton County then reported a total of 527,925 ballots counted. Petitioners contend that this statement was misleading because 511,343 was not reported by Fulton County. Rather, the recount had not yet finished, and 511,343 was merely an interim number used to keep track of votes already counted at that point in the process, which is an understandable explanation for it. According to petitioners, the 527,925 ballots counted the next day was the final number after counting had actually finished. As to ballot images and duplicate ballots, petitioners argue that the affidavit's statements were misleading. Specifically, petitioners contend that the affidavit omitted several basic facts, including that in 2020, Georgia law did not require the preservation of ballot images, that saving ballot images was optional for aggregating election results, and that investigators found that scanning some of the ballot images multiple times did not affect election results. How can that be? Maybe they just mean that it didn't change the end result of who won and lost, because it would certainly affect the number. Okay, so it may not affect the results of who won and lost. Seems like it could, though, for tighter races that are down ballot. Additionally, petitioners assert that the ballot images could not have been the basis for a violation of 52 USC 20701 because they are not records related to an act requisite to voting as required by the statute. Finally, they claim that the affidavit omitted any innocent explanation for scanning duplicate ballots. I don't think it has to include innocent explanations. There's like a search warrant for a person's property doesn't have to omit innocent explanations as to why they have shell casings and other things that correspond to a suspected crime. It doesn't have to. It doesn't have to have an innocent explanation included. There could be one, but it doesn't have to. That doesn't have to be included in the application. Okay, petitioners further also innocent explanation for witnesses' conclusion that missing ballot images meant that duplicate ballots were counted. Same remark. They don't have to include an innocent explanation in the application for the search warrant. Petitioners further assert that the affidavit's statements concerning tabulator tapes were misleading. While the affidavit quoted a witness who called these tapes the Holy Grail for calculating the final ballot count, petitioners argue that the affidavit omitted findings from the Georgia Secretary of State's investigators that tabular tapes were not part of determining official election results. So, on this whole thing about innocent explanations and why those don't have to be included in a search warrant application. So, say police want to search a property because they're looking for an individual and they have a description of this individual, and a witness tells them, I saw someone of that description going into that property. They need access to that property, and they wouldn't be denied the search warrant because, well, anybody could be dressed that way. So let's say there's a robbery and the individual is dressed with black pants and a red shirt and carrying a blue bag that looks heavy. Well, there are innocent explanations for someone wearing black pants, red shirt, and carrying a blue bag that looks heavy. But that doesn't mean that because of that, the search warrant should be denied for that property if the police think that the suspect stashed the stolen property in that location, right? There might be an innocent explanation, and it might be someone completely different who didn't rob anybody, but they have a description and they have some things that correspond to what they're looking for and what they believe might be there. That's all they need. They don't have to include innocent explanations. And the reason, it's obvious. If you always had to counter it with innocent explanations, no search warrant would be approved because you can make up innocent explanations for all sorts of things. All right, finally, petitioners contend that the affidavit omitted several facts about the biases of the witnesses. First, the affidavit said the criminal investigation began with a referral from Olson. But petitioners say the affidavit left out the fact that Olson had been sanctioned by numerous courts for making unsubstantiated claims about elections and had been disciplined by the State Bar of Arizona regarding the same conduct. Second, petitioners argue that the affidavit failed to include information that one witness was referred to the FBI in 2023 for sending threatening messages to members of the state election board and to Georgia Secretary of State Raffensperger. Third, petitioners contend that the affidavit relied on witnesses who, among other things, participated in Kari Lake's failed efforts to contest the 2022 gubernatorial election in Arizona and reportedly run a Telegram channel devoted to election conspiracies. That's concerning as to the credibility of these witnesses. But search warrants get approved thanks to witnesses who have checkered past all the time. In some, petitioners ask the court to examine the aggregate of these omissions and find that the affidavit would have lacked probable cause if the information identified above had been included. They further contend that Special Agent Evans was reckless in making the omissions and, as a result, disregarded their constitutional rights. This court recognizes that petitioners think the affidavit should have contained additional information. However, some of the omissions that petitioners take issue with are not truly omissions at all, but rather appear in the affidavit in a different form. For instance, petitioners argue that the affidavit omitted important information about the context regarding duplicate ballot images, but Special Agent Evans' description of the investigation did include a witness statement indicating that, quote, the images are just duplicates, and that, quote, concern was less about the images and more about the ballots and voter count. Similarly, while petitioners fault the affidavit for purported omissions as to pristine ballots, the affidavit contains statements from one witness explaining that, quote, there would be pristine ballots in every election, just like petitioners say, and offered one explanation for the occurrence of such ballots, which was the damaged ones. The pristine ones are to make up for, or the substitute for, the damaged ones, right? Likewise, though petitioners contend that the affidavit made material omissions concerning tabulator tapes, the document did incorporate a witness's statement that, quote, the original tabulator tapes were not used during the recount because the ballots were scanned utilizing a different machine, and the ballots were what mattered. Although this court does not entirely agree with petitioners' characterization of all the alleged omissions in the affidavit, the court does recognize that the affidavit was defective in some respects. For instance, the affidavit stated that Fulton County reported 511,343 ballots on the day of the deadline to report the recount results, 17,434 ballots short of the original count. The affidavit then asserted, without further explanation, that Fulton County reported a total of 527,925 ballots the following day. As petitioners pointed out in their briefing and during the evidentiary hearing, this statement was misleading given that there was a scanner programming error and Fulton County was unable to finish scanning the ballots on time. Thus, the 511,343 was an internal report that was used to understand where the count was at in the count as opposed to the final number. A completely understandable and innocent explanation for something that at first is like, what? What? That's a huge difference. What's going on there? That draws a lot of suspicion, right? And this is something I've seen repeated a bunch, and used to then launch into various theories about malfeasance that was occurring. But there's a perfectly understandable and innocent explanation, as I just read right here, for those numbers. The court also agrees with petitioners that some of the affidavit statements regarding the importance of ballot images and tabulator tapes are troubling. For instance, while the affidavit included one witness's statements expressing concern over modification dates on ballot images, image files long past the conclusion of the 2020 election, it failed to explain that these modification dates could have been caused by personnel from the Secretary of State's office simply renaming the file. Likewise, the affidavit's inclusion of one witness's description of tabular tapes as the Holy Grail is confusing when read in conjunction with another witness's statement that the tapes were not even used during the recount. Again, the court agrees with petitioners that such features within the affidavit are problematic. Nevertheless, the court is cognizant that its task is to assess whether respondent callously disregarded petitioner's rights, as respondent observed during the evidentiary hearing. The court may think the affidavit is a B or B minus or some other grade, but that's not the issue. Rather, the issue is whether petitioners have supplied enough sufficient evidence that their rights were callously disregarded. In analyzing whether callous disregard exists here, the court does note the court notes that the affidavit in this case was 18 pages long and included statements from more than 10 witnesses concerning the 2020 election in Fulton County. While the affidavit references witness statements critiquing the election, describing errors, and discussing potential wrongdoing, it also included other witness statements suggesting that these perceived issues during the election did not go beyond benign human error. Indeed, at least 20 times the affidavit included contrary information and perspectives, which I really don't think it has to do. It seems to the court that Special Agent Evans presented the magistrate judge with facts that both hurt and helped him. While the affidavit was certainly far from perfect, this is not a situation where an officer left out all the facts that might undermine probable cause or where an officer intentionally lied. Ultimately, when examining the totality of the affidavit, including Special Agent Evans' inclusion of contrary information and the supposed omissions, the court cannot say that the affidavit was so deficient in its shortcomings that those rise to the high threshold of callous disregard. Petitioner's argument that the manner in which the warrant was executed constitutes callous disregard. In addition to their arguments concerning the substance of the affidavit, petitioners contended their rights were callously disregarded due to the manner in which the warrant was executed. I think this is where Bailey and Gabbard being on site might come up. I'm not sure. Petitioners argued that the manner of the search was unreasonable because it interfered with state sovereignty and the ongoing civil proceedings. Okay. Petitioners also assert that the manner was unreasonable because of the statute of limitations for the two potential offenses the affidavit cites has expired. Petitioners argue that when respondent seized the election records in this case, quote, it did so in callous disregard of Georgia's constitutional rights, powers, and responsibilities under the Electors Clause and the 10th Amendment as implemented through the state's election laws. Petitioners contend that by seizing the records, the Board of Elections for Fulton County is prevented from carrying out its duties under Georgia law to guarantee the secrecy of the ballot and to ensure that ballots and other election records are held under seal by the clerk. In short, petitioners claim that the seizure of ballots infringes upon their sovereign interest in safeguarding election integrity, maintaining accurate records, and reassuring voters that their ballots will not be manipulated or misused. As stated above, petitioners assert that the seizure interfered with their ability under the Electors Clause and the 10th Amendment to administer elections. The court disagrees. The records at issue in this case concern the November 2020 presidential election, and the seizure of those records occurred in January 2026. Thus, the seizure of the records did not interfere with Fulton County's ability to carry out the 2020 election because it happened over 5 years after the election took place. Petitioners also argue that the seizure prevented the Board of Elections for Fulton County from carrying out its duties under Georgia law to guarantee the secrecy of the ballot and to ensure that ballots and other election records are held under seal with the clerk. Petitioners, however, have presented no evidence that the election materials were manipulated, misused, or publicly disclosed after the seizure. In other words, petitioners have not shown that the secrecy of the ballot has been compromised by the seizure. Moreover, this argument is weakened by the fact that prior to seizure, the Fulton Board of Elections had already received an order from the Superior Court action to provide those copies to the State Election Board. Consequently, the BRE was poised to release copies of those same records to the State Board election already. And so that undermines petitioners' argument that the seizure inflicted callous disregard upon them by interfering with the secrecy of the ballot or the sealed nature of the records. And some petitioners have not demonstrated how the seizure of materials from an election that occurred 5 years ago infringes upon their sovereign interest in safeguarding election integrity. Weak. Moreover, petitioners did not present any evidence that voters are concerned that their ballots will be manipulated or misused, and they did not explain whether these purported concerns relate to old ballots in the 2020 election or uncast ballots in future elections. Accordingly, the court finds they haven't met the threshold for that. Okay. Interference with ongoing civil procedure. As stated previously, there are 2 civil proceedings involving the 2020 election records, the Superior Court action and the federal action, that were stayed after the search warrant was executed. Petitioners contend the respondent's seizure was unreasonable because the seizure was made without regard to the consequences to these other proceedings. Petitioners further argue that the criminal investigation was in reality a late-breaking pretext for DOJ to get the documents after it suffered setbacks in these actions. Respondent, on the other hand, argues that no callous disregard exists here because the government can bring parallel actions and very frequently does pursue both civil and criminal proceedings. That is true. As an initial matter, the court agrees with DOJ that they can do simultaneous actions. Although the general rule provides that the government may bring parallel actions and conduct simultaneous investigations, an exception does exist. Indeed, a violation of the Constitution may occur where two arms of the government collude in bad faith to deprive a defendant of his constitutional rights. Such bad faith collusion generally involves affirmative misrepresentations or trickery or deceit by the investigating authority to get the defendant to voluntarily turn over documentary or physical evidence relevant to the criminal investigation. Petitioner suggests that respondent obtain the warrant in bad faith after encountering procedural hurdles in the Superior Court action and the federal court action. Given this argument, it is important for the court to detail the relevant timeline. On November 5th, 2024, State Election Board issued 2 subpoenas to the Fulton County Board seeking election materials from the 2020 election. On the date that the responses to the subpoenas were due, November 18th, 2024, the BRE filed the Superior Court action seeking to quash the subpoenas. Over a year after the action was filed, the Superior Court held a hearing and a ruling was issued on December 22nd, 2025. In its order, the Superior Court determined that the Fulton Board of Elections was required to comply with the subpoenas. In other words, produce those records to the State Election Board, but the State Election Board should bear the cost of the compliance, which was $400,000. The parties were ordered to provide evidence regarding cost no later than January 14th, 2026. On October 30th, 2025, while the Superior Court action was ongoing, and before the Superior Court determined that the subpoenas would be quashed, Harmeet K. Dillon, shout out, an assistant attorney general with the Civil Rights Division, sent a letter to Sherry Allen, the chairperson of the BRE, requesting access to Fulton County's election records. Specifically, Dillon asked Allen to present for inspection all used and void ballots, stubs of all ballots, signature envelopes, and corresponding envelope digital files from the 2020 general election in Fulton County. By the way, you know, guys, I did a video the other day on the same topic, what's going on in Fulton County, right? Let me show you something. Here it is. This video. DOJ investigators gain access to Fulton County's 2020 election records. Remember I did that? Check this out. Oh, wait. Oops. I need to look at this one. View activity. Likes. Guess who liked my X post that had that video in it? Kind of cool. All right. In response to the request, the BRE stated it could not comply because it was not in possession of the records and the records were being held by the clerk under seal. November 21st, 2025, Dillon made an identical request for inspection of the records to the clerk and the judge in the Superior Court action. When the information was again not made available for inspection on December 11, 2025, the Attorney General filed the federal court action seeking a court order to allow access to the records. 11 days later, on December 22nd, 2025, the Superior Court denied Fulton County's motion to quash. On the morning of January 5th, 2026, after the Superior Court had already ordered the BRE to produce the election materials to the SEB, Albus received Olson's criminal referral regarding the 2020 election in Fulton County. Later that day at 8:36 p.m., the clerk filed a motion to dismiss the federal court action. The day after Albus received the referral and the motion to dismiss was filed, the FBI opened an assessment. On January 14th, 2 days after Special Agent Evans put in a request to do so, the matter was opened as a full investigation. Special Agent Evans began drafting his investigative summary based on witness interviews on January 19th, 2026, which he converted to the format of a search warrant affidavit on January 22nd, 2026. Special Agent Evans ultimately sought the warrant on January 27th, 2026, and it was signed and executed the following day. The timeline set forth above demonstrates that there has been ongoing activity involving the 2020 election records since at least November 2024, when the SEB first requested the records. Yet the warrant was not sought until more than a year later. For the reasons explained below, the court is not persuaded that the petitioners have shown that respondent created an ongoing criminal investigation to sidestep procedural hurdles in the Superior Court action or the federal court action, which I don't think they did either. I see it could be characterized as that, and I think it's fake news. Petitioners point to no evidence to support the theory that the order denying the BRE's motion to quash prompted the FBI's criminal investigation and seizure at issue in this case. The Superior Court had actually ruled in favor of the SEB, granting it the right to access the documents. If petitioner's theory is correct, that the warrant was obtained to avoid delays and procedural hurdle of paying costs, the court does not understand why the Superior Court action was pending for more than a year without the FBI taking action. Indeed, action was only taken after the SEB prevailed. It seems to the court that if the two governmental entities were truly acting in bad faith to sidestep the Superior Court action and expedite access to the records, the FBI would have obtained a warrant much sooner. Actually, let me look at these footnotes. Okay. Petitioners also assert that the warrant was in response to delay in the federal court action. The only delay petitioners identified in the federal court action, however, was the clerk's motion to dismiss. Problematically for the petitioners, the evidence shows that the criminal referral to the FBI was made before the clerk filed her motion. The fact that Olson referred the matter to the FBI before the motion to dismiss was filed cuts against the contention that the criminal investigation was a pretextual response to delay in that case. Without any other evidence on the point, the court finds that these facts fall short of callous disregard. In sum, the court is not convinced that the criminal investigation was created in response to procedural hurdles in either the Superior Court or the federal court action. Let me look at these large footnotes right here. Well, they're not large, there's just three of them. Earl. Statute of limitations. Finally, petitioners argue that the manner of the seizure was unreasonable because the statute of limitations for the two offenses listed in the affidavit has expired. Notably, petitioners admit that the potential expiration of the limitations period does not necessarily negate probable cause. Yet petitioners argue that the possible expiration of the statute of limitations caused the manner of the seizure to be unreasonable because DOJ lacked any legitimate interest in executing the seizure. The petitioner's view is that the issue is not that a statute of limitations defect per se defeats probable cause. It is that respondent does not have a legitimate, let alone significant, interest in criminal investigation that cannot yield a criminal prosecution, especially when balanced against petitioners' competing governmental interest and retention of their own records. The court acknowledges that this case involves records from the 2020 election and that the limitations period for the statutes identified in the affidavit is 5 years. The court further recognizes that many parts of the affidavit refer to activity or potential wrongdoing that occurred more than 5 years ago. While this may be true, the court cannot ignore that a witness told Special Agent Evans that some of the ballot images may have been modified as recently as January 11th, 2024, which is well within the statutory period. Oh, oh. The 11th Circuit has held that whether a valid statute of limitations in defense exists is not a cut and dry matter. Given the complexities in determining whether a statute of limitations defense is viable, the limited amount of evidence in the record and Special Agent Evans' assertion that at least part of the investigation involves activities that occurred during the limitations period, the court is not convinced that the respondent has no legitimate interest in the election records. So the judge is saying, yeah, I'm not convinced that there isn't a there. In short, while the court understands the petitioners believe that the statute of limitations has expired for all potential criminal activity and speculate that criminal charges will never be brought, this court finds that the execution of the warrant under these circumstances does not give rise to a constitutional claim, let alone a showing of callous disregard for constitutional rights. You guys just keep going right on and believing that there won't be any criminal charges coming. Just go ahead and keep believing that. Ultimately, the potential expiration of the statute of limitations does not demonstrate the petitioner's constitutional rights were callously disregarded. In summary, petitioners have not shown that their rights were callously disregarded. Court also finds, when considering the cumulative weight of petitioner's argument concerning defects in the warrant and their argument concerning the manner in which the search was executed, they have not demonstrated callous disregard. Okay. Other factors. Is this where we're going to hear about Gabbard and Bailey being there? He may not even talk about it. Although petitioners bear the burden of establishing that the court should exercise equitable jurisdiction, which has been described as exceptional and anomalous, petitioners did not address the 3 remaining Ritchie factors in detail. This is significant because the 11th Circuit has emphasized again and again that equitable jurisdiction exists only in response to the most callous disregard of constitutional rights, and even then, only if other factors make it clear that judicial oversight is absolutely necessary. Meaning, a court shouldn't step in and stop the search warrant, and the court shouldn't jump in between the investigators and their search warrant and the material seized and all of that unless it's absolutely necessary. That's what they mean by judicial oversight. And we're seeing that like in the Hannah Tansen, Perez Lagones case where the defense contractor stole classified intelligence and gave it to Washington Post reporter Hannah Tansen. And then that stuff wound up in her articles over a span of like 6+ weeks or something. The court stepped in and paused DOJ's ability to go through that material because there were First Amendment concerns, there was client privilege concerns, work product concerns, all of those things. So the court is conducting judicial review or oversight of the seized material in that case. They didn't throw out the search warrant. They didn't invalidate it. They didn't tell. She filed the same action to return a property of 41G. Her and WAPO did. And the court isn't telling the DOJ, you have to return all this stuff. They're saying, no, you need to have a separate team, a filter team come in, filter out what actually was responsive to the criminal investigation and from what's not. And then the court is going to conduct judicial review over it to make sure that it's not something protected or off limits because of 1A. And then they get to go ahead with their process of using that, going through those materials and seeing if it informs their investigation. All right, individual interest and need for the material. They don't have a need for it. The court notes that an interest in the property is not enough anyway. Because a possessory interest alone is not enough to establish need, just like it wasn't alone enough that Trump just happened to want to be in possession of his favorite CDs and golf memorabilia. He didn't have a need for them. That's not enough for them to be returned. They were eventually returned. He got his stuff back. Without any specificity, it is unclear whether petitioners need all the documents to defend against the allegations or just some of them. Moreover, the clerk once requested permission to destroy the records. Oh, isn't that interesting? You guys say you have a need of this stuff and you got to protect it, but at one point you requested the ability to destroy it. That undermines everything you're arguing for. I have an immediate return, need to return this stuff so I can destroy it. In the court's view, all right. In the court's view, if the records were necessary to combat allegations of fraud, the clerk would not have sought to destroy them. Even more telling, when the FBI seized the election records, the Fulton County Director of Registration and Elections stated that the FBI could make paper airplanes with the records for all she cared. Whoa. If petitioners truly need the records, this statement makes little sense. Wow. Wow. Okay. In further considering petitioners' argument that they need the documents to combat election misinformation, the court cannot ignore the fact that petitioners have copies of the documents. Oh. The evidence at the hearing established that the respondent has made copies of the seized election records and provided those copies to petitioners. Because petitioners have copies, this court finds that petitioners already have the ability to rebut any attacks on the 2020 election and respond to any allegations of misconduct. This got fun, didn't it? Petitioners also contend that they need the election records to respond to open records requests. Well, you got copies of them. At a minimum, the copies allow petitioners' ability to provide some information to the public if requested. At the hearing, petitioners admitted that no open records request had been made. Moreover, petitioners failed to present any evidence concerning the number of prior record requests which documents were sought in those requests and when the most recent request was made. The court thus has no way of determining whether petitioners are likely to get open records requests while respondent has the records. Without any evidence, the court is not persuaded by petitioners' argument that they need the documents. Lastly, petitioners assert that they need the documents so they can comply with orders in other civil cases. The court finds this argument unavailing because petitioners have failed to identify which documents are at issue in those cases. Okay. In summary, the court finds that petitioners' stated needs for the return of the documents fall short of what is demanded in Richney and its progeny. Accordingly, the factors weigh against exercising jurisdiction here. Irreparable injury. For irreparable injury, courts focus on the harmful effects the loss of property wreaks on the movant. In claiming that they will be irreparably harmed by the FBI's continued retention of the seized records, petitioners repeat many of the same arguments that they made as to why they need the records. Such as they argue that they will be irreparably harmed because they need to show Fulton County voters that they, not the federal government, are in charge of elections. They also claim that they will be irreparably harmed because they must comply with open records requests. Finally, they assert that they will be irreparably harmed because they need to be able to respond to the constant barrage of criticisms concerning the 2020 election. For the same reasons discussed in the preceding section, these arguments are unpersuasive and fail to show irreparable injury. In addition to the repeated arguments, petitioners also contend that they will suffer irreparable injury because 1, They will be unable to verify the chain of custody of the election returns. And 2, respondent may disclose personal identifying information on the records. In the records. In the court's view, these arguments are vague and speculative. The court cannot ignore that one of the reasons that the FBI seized the election records was to investigate various chain of custody issues that petitioners now want to protect. And indeed, the affidavit stated that a nonpartisan report found that the absentee processes were extremely sloppy and replete with chain of custody issues. The court thus does not find that the petitioners, Fulton County, will be irreparably harmed because they will not be able to address the chain of custody issues. And again, it cites the Mar-a-Lago case. Sometimes I hit a home run. All right. The court is also not convinced that petitioners will suffer irreparable injury due to the potential disclosure of personal identifying information. At the hearing, petitioners complained that the copies that respondent voluntarily provided to them contained personal identifying information, which, in their view, demonstrated that respondent will not treat the election records with care. The fact that respondent already copied the materials and gave those copies to you does not suggest that DOJ will disclose that same information to anyone else. Moreover, petitioners fear that Fulton County fears that DOJ will publicly release the sensitive personal information from the documents. And that appears even more improbable given that DOJ's assertion that it seized the documents pursuant to an ongoing criminal investigation, the substance of which DOJ has consistently argued is privileged. Yeah, try getting DOJ to tell the world about the criminal investigations they're doing. They're kind of famous for hiding behind FOIA exceptions. What is it? 7E or whatever. That ongoing criminal matter can't give you this FOIA. Ultimately, after considering petitioners' arguments as to why they will be irreparably injured, yeah, it doesn't weigh. All right, under the final factor, the court must consider whether the movement has adequate remedy. Petitioners argue that they have none, but they have copies of it. The only remedy is a return of property, they argue, but relying on the 11th Circuit decision in the Mar-a-Lago case, respondent argues that this factor weighs against petitioners because there is no underlying harm to remedy. There's no lawful basis for Fulton County to seek a return of the records. The court is not convinced that either party's arguments are entirely correct as to this factor. As mentioned directly above, petitioners essentially argue that they have no adequate remedy at law because they have no other legal means for seeking the return of property. Notably, the 11th Circuit, in looking at the Mar-a-Lago case, said, quote, "This is not a sufficient justification for finding no adequate remedy of law." The court reasoned that, at least in part, that it was unwilling to weigh this factor in favor of the equitable jurisdiction because any subject of a search warrant would like all of his property back before the government has a chance to use it. Like, everybody would want that. Ultimately, the Mar-a-Lago case seems to suggest that a plaintiff must argue something more than the mere inability to seek the return of property for the time being. As to DOJ's argument that this court recognizes that in the Mar-a-Lago case, the 11th Circuit said that the real question is adequate remedy for what? And that if there has been no constitutional violation, much less a serious one, then there is no harm to be remediated in the first place. Relying on the Mar-a-Lago case, respondent essentially contends that the adequate remedy at law factor automatically weighs against equitable jurisdiction whenever there is no callous disregard. I could never have predicted. I mean, I did predict that the Mar-a-Lago case was going to set a precedent, right? I mean, I did over and over and over and over and over again tell you guys and everyone else who would listen, the Mar-a-Lago raid would end up becoming a template for future FBI raids. And we would see FBI raids in the news and we would be like, whoa, that's good news, right? We're freaking here, folks. We're freaking here. This is it. This is it. This is what I was freaking talking about. This is what I've been trying to tell y'all for 3 years now, 4 years. But I never predicted it would come up in Fulton County in the 2020 election. I never thought it was going to go here. But look, this is Mar-a-Lago, Mar-a-Lago, Mar-a-Lago. How many times is Mar-a-Lago cited in this judge's order? I mean, over and over and over again. It's beautiful. Mwah. Or actually, maybe I should just be like, swing the bat, tossed it, home run. All right, the court is sympathetic to petitioner's argument that there's only available option to pursue the election records and blah, blah, blah. Indeed, where likely is proceeding to be available in the future, the plaintiff can vindicate his rights and courts are authorized to find that a plaintiff has an equity remedy, blah, 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 blah. I kind of don't care anymore because, like, he's just dealing with the odds and ends. In this case, the FBI seized the election records on January 28th. Petitioners filed this on February 5th, only 8 days later. It's the court's understanding that at least a portion of that time, this action has been pending. DOJ had not analyzed the documents to determine whether they contained evidence of criminal activity. And petitioners have not presented any evidence that DOJ does not intend to bring criminal charges. They speculate they can't be brought because of the statute of limitations. Given the recency of the seizure and the fact that DOJ paused its investigation when this action was filed, the court is not willing to speculate, at least based on the record, that no criminal action will ever be brought. Yeah. But I'm fine with them believing it won't be. This is important because if criminal charges are initiated at some point in the future, petitioners could vindicate their rights in that criminal proceeding. In short, in light of the early stage of the investigation and the absence of evidence regarding whether a future proceeding is likely, the court finds that this factor weighs slightly against the exercise of equitable jurisdiction. Okay. Finally, the seizure in this case was certainly not perfect. However, the court has considered all these factors. They weigh against it. Fulton County, you lose. DOJ, you may proceed with analyzing the documents in the case. Bam. Bam. I wonder what they will find. And at the same time, this is happening. There's also, where is it? Where is it over here? Different case. That's a difference. Where is it? Aha. The same time this came down. So this was on, what's the date on this? So May 6th. So just a couple days before Fulton County got this order and lost this effort, they got grand jury subpoenas from Dan Bishop for all of their employee records. The subpoenas want all of this. Rosters of all election staff, volunteer and paid, and where they were assigned. Individuals to mail ballots, voter review, mobile voting locations, all this stuff. 1-2 punch. Awesome. Okay. Guys, that was a long read. I thank you for sticking with me through it. If you would like to support my document addiction and coffee habit, the links are in the description of this video. I have a link tree somewhere, either in my profile page or in the description of the video. And there you can find all the ways to follow, watch, listen, and support the show. Purchase something for yourself or a friend at Benson Honey Farms, Bootleg Products, or Manly Cans. They'll kick a few dollars my way out of your purchase. Go to ko-fi.com if you just want to buy me a cup of coffee. Go to justhuman.substack.com if you would like to buy me a cup of coffee once a month, and also contribute a few dollars to my Pacer fund so I can keep on buying documents and going through them and making sense of them and reading them to you and having a great time doing it so that we're both better informed and a bit more positive about the future, right? All right. Thanks.